Parties do not dispute the positive DNA results reviewed. Parties denied family violence. Both parties are in agreement to a mutual non-disclosure. Parties are in agreement to a geographic restriction, with the mother designating the primary residence of the child or children to Dallas and contiguous counties. Parties stipulate on the wages, gross income, net resources, and agree that child support should be set at $217, medical support to be set at $75, and the child to remain on government medical. Parties are in agreement that there should be a retroactive judgment taken in the amount of $2,492 to be paid off at $63 a month. Court cost is billed to the father. No name change is needed. The child already has the father's last name. That is the extent of the agreement. I will now call the mother. Ma'am, can you state your name for the record?
Yes, hi, my name's Kimberly Akibu.
And ma'am, did you hear the agreements that I read into the record?
Yes, ma'am.
Are those portions still your agreements?
So the non-disclosure of the address, I'm not in agreement with that. If my child is, if we're going to be having to make a decision if she's going to be going with him for visitations over at his home, or if because I wanted to do supervised visitations, so that he requested a non-disclosure of the address, then I'm not in agreement with that on his part.
Okay, we'll get into that in a moment.
Okay.
Besides that, were you in agreement to the other portions I read?
The child support that's set at the 200, and I think you said $17, that's only due to him not legally being able to work because he's not a citizen of this country, correct? And then once he starts working, we can request a modification for that increase, correct?
Ma'am, I'm not the witness.
She's asking if you're in agreement with it. If you're not in agreement with it, we're not asking for an explanation. So either you're in agreement with it or you're not.
I'm not in agreement with the amount of child support for right now, the $217. No.
Okay.
But I know that that's due to certain things, so I just wanted to get clarification.
That's what you told somebody earlier. That's why she's asking you and why she presented it as an agreement. If you change your mind since then, that's different. But earlier you told that other person in the previous meeting that you agreed to child support at 217 and the non-disclosure. So you're changing your mind on those two issues.
Yes, Your Honor, you are correct.
All right, guys, today we are jumping into a courtroom hearing that starts calm but turns tense almost instantly. What looked like a routine agreement completely shifted when the mother suddenly backed away from key terms involving child support and address disclosure. The judge quickly noticed the confusion and began pressing her for direct answers, setting the tone for a hearing filled with frustration, interruptions, and serious custody concerns.
I did agree to that, but I was just wanting to reconfirm that was what we agreed to, was that was because he's not working right now. So she said—
I don't know what the conditions were, ma'am. I wasn't there.
Okay.
Either you agreed to the 217 or you don't agree to the 217. You agree to the non-disclosure or you don't agree to the non-disclosure. It's a very simple question, yes or no, and not conditioned upon anything else.
Okay,
So
well, no.
217?
No, Your Honor.
Okay, everything else besides those two things that we talked about, are you agreeing with everything else?
Yes, sir. Yes, Your Honor.
Okay, thank you. All right, Ms. Correa, go ahead.
Okay, I call the mother. Ma'am, can you state your name for the record?
Kimberly Akibu.
Okay. Oh, I had already called you. Okay, let me move on. Let's talk about the child support. Ma'am, you stated that you were previously in agreement to the 217. You understand that the state is proposing that. Do you understand that?
Yes, ma'am. From my knowledge, that amount was proposed due to him not legally working right now.
Okay. And ma'am, do you understand that later you can ask for a modification?
Yes, ma'am.
If the father becomes employed? Okay.
Yes, ma'am. That's what I was just wanting to confirm. Yes, ma'am.
Okay, thank you. And ma'am, who does the child live with?
She's with me.
Okay, ma'am, do you have an active protective order?
What is that? Sorry.
Did a judge grant you a protective order against the father?
No, ma'am.
Okay. Do you have an upcoming criminal court date?
No, ma'am.
Okay. Has there been family violence in the last 2 years?
No, ma'am.
Okay. Um, are you wanting to be named the sole managing conservator or the joint managing conservator?
So, yes.
Okay. What is the reason you don't want to do joint?
Okay, so the reason that I'm not wanting to do joint is that I'm asking for the sole due to our daughter was born with trisomy 21, which is Down syndrome. Since our daughter was born with this disability, he pretty much hasn't been to any doctor appointment, no therapy sessions. He doesn't know anything about her diagnosis. He doesn't know how to handle her diagnosis or to care for her, given that she has this diagnosis and requires special attention. In addition to that, he's missed out on a nice portion of our daughter's life. And then I just recently determined that he has still been doing some pretty heavy drinking.
Because this part completely changes the emotional weight of the case. The mother explains that the child was born with Down syndrome and claims the father has missed appointments, therapy sessions, and major parts of the child's life. She also raises concerns about drinking and argues that he lacks the knowledge needed to properly care for a child with special needs, making this one of the strongest moments of the hearing.
He did have a public intoxication charge that he went to jail for recently. And since then, I just found out that he is still currently drinking heavily. And then also him and his spouse has made some serious derogatory remarks, basically mocking my child's diagnosis, which makes me feel she will not be cared for appropriately while she's under their custody. And then in addition to that, due to the absence of him in our child's life, when he do make efforts to come around, which has been maybe like twice or 2 or 3 times within the year of our baby's life, she cries hysterically the entire duration of the visit because she is not familiar with him and she's completely uncomfortable. So due to all of these reasons and the negligence that he has done towards our child and just neglecting to even build a relationship with her, and then she has these special needs that requires additional attention and it has to be adhered to. He doesn't know anything about her. Again, he's not been to one doctor's appointment, not one therapy session. He doesn't know what she needs, what she requires on a day-to-day basis, what her daily essentials and necessities are, to keep her upgoing and to keep her strong and thriving in life, that she requires these additional supports with her diagnosis. So I am requesting that.
Thank you. Understood. Are these the same reasons you're requesting an exchange location at the clubhouse on Lake Carolyn Parkway?
Yes, ma'am, that is absolutely correct. I am requesting that it is supervised visitations because, again, he does not know my child.
Objection, narrative response.
Sustained.
Thank you. Ma'am, is this the reason that you are the reasons you testified earlier, why you're requesting an injunction on drug and alcohol use?
Yes, ma'am. I was just advised yesterday from his spouse.
Objection, narrative response.
Sustained.
Does that mean that I stopped talking or?
That means you stop talking.
Yes.
Okay. Okay.
Yes.
We can
You'll
make it
have
simple.
yeah.
Make it simple, Mr. Akubu. We don't need
Okay.
to. I hear things very well the first time.
Okay.
I don't need to told to me 10 times.
Okay.
And you're wanting the visitation to be supervised by Janice Williams
Yes, ma'am.
and supervised and phased in, correct?
Yes, ma'am.
I pass this witness. I call the father. Sir, can you state your name for the record? You're on mute. Let me send you.
John O'Baker.
And sir, did you hear the agreements I read earlier?
I sure did.
Are those portions still your agreements?
In as much as I don't have a job right now, but I'm okay with the payment.
This is where the courtroom tension starts rising fast. As the mother continues explaining why she wants supervised visitation, objections begin flying in, and the judge repeatedly stops her from giving long, emotional answers. You can clearly see the court trying to separate emotional accusations from legally relevant facts, and the frustration in the room becomes impossible to ignore.
But there are some issues I need to address. My
All
consent.
right.
Yeah. So, first and
Sir.
foremost,
Hold on. We just need to know if you agreed to the portion she read. It's very simple.
yeah, the first portion, yes. The second, no.
Okay. Sir, are you wanting to be named joint or joint managing conservator with the mother?
Joint. Because
Okay.
I want to be in the child's life, so joint.
Objection, narrative response.
Joint.
Sustained.
Joint.
Sir, is it true that you're requesting unsupervised daytime visits from 1 to 6 p.m.?
Yes, I am requesting that.
And then you're requesting a standard possession order after the child is 4 years old.
Yes, sir. Yes, ma'am.
Okay. And that you are wanting the exchange location at Starbucks at O'Connor Road in Irving, Texas.
Yes, ma'am.
Okay, sir, this is your time to tell us relevant information.
Okay. So, first and foremost, the first thing she said, I haven't been to the, sorry, she said I haven't been to the child's appointments. How am I gonna go to an appointment that I have no idea about? You are with the child. You get appointments 2 weeks out.
Sir,
You never.
I'm not your child's parent. So when you address you, you're addressing me.
Oh, sir, I'm addressing. Yes, sir. That's what I'm saying.
So,
So
but
she's
no, you're
saying
saying you. Go ahead. Yeah, go ahead. So she says
so
better than.
she is saying I didn't make no appointment. I didn't come for the child's medical appointment. I have no knowledge of it. You are with the child. It's okay for you to communicate with me and tell me this is when the child has an appointment. She never communicated none of those with me. That's the first thing. And then the second part, she said the child is not comfortable being around me. How's a child gonna be comfortable being around me when you bring other men around this kid? Because every time you say, oh, the child has a stepfather already, you don't need to be around. So when the child sees different men, how is she gonna know I'm her dad? Of which we're going off of the fact that I don't even know if this child is mine, but I'm doing all I can as a father. I'm the one who filed this child support because I keep getting constant threat from Mrs. Akibu. In as much as she's married, she's still.
Because now the father finally gets his chance to respond, and he wastes no time pushing back. He claims he was never informed about medical appointments, and argues that the child barely knows him because he was kept away. The hearing quickly turns personal as accusations about relationships, threats, and communication problems start spilling into the courtroom, forcing the judge to step in repeatedly.
Married to her ex-husband right now. They just separated. She's a legally married woman as we speak. But I don't see any reason why you go about messaging all my friends on Instagram, even calling my wife,
Objection,
Anima.
relevance.
Sustained. Okay, let me just.
And then she spoke about therapy.
I understand, Mr. Obaka. I get it.
Yes, sir. And she spoke about
Okay,
therapy.
stop. That means stop. I'm not here trying to resolve all your issues. Y'all got some issues, but I'm not going to resolve all of them today. Okay,
Right.
so
So,
I just need to hang on. One thing I need to know what to do here is about non-disclosure.
yeah, about the
Normally,
visitation.
I have not asked the question yet.
Yes, sir.
So I'm going to ask y'all both the same thing because I don't understand what y'all are asking for on the non-disclosure. Y'all both testified there's been no family violence. So normally,
Right.
don't interrupt me. You understand that?
Yes, sir.
Okay, so y'all both testified there's been no family violence. Y'all obviously don't like each other, but that's not family violence. Um, and so usually what would happen is y'all would have to let each other know where your residence is. She would have to let you know her residence. Sir, you would have to let her know where your residence. And anytime y'all moved, you would be obligated to let the other party know where you moved to. Doesn't mean that you have to tell them your whole plan of every minute you're going to spend with your child. It just means this is where I'm going to in my nights. I'm going to spend the night there, kind of thing, during visitation or for custody or whatever the case may be, and that address is your actual residence address, not some grandparent or some other mailing address, PO box or something like that that you're not actually living at.
Yes, sir.
So initially it was announced with Ms. Correa that y'all wanted a mutual non-disclosure, and then we kind of blew up from there. Mr. Obaka, are you asking for your address not to be disclosed, or are you okay with it being able to share that information?
The only issue I have is the fact that I've been threatened a couple of times, and this is an evidence.
I can't
That's
look at your phone,
further.
sir. I can't look at your phone. Can you just tell me?
I don't have a problem with her knowing my address,
Okay,
but
that's all I needed to
it's
know.
about my safety
That's all I needed to know.
because her mom threatened me. She
So you're
threatened me
okay with
too.
her knowing your address, right?
Yes, sir.
Okay, perfect. That's all I need to know. And Ms. Akibu, same kind of questions about the non-disclosure. Is there some reason why your address should be secret from Mr. Ogbaka?
Um, I mean, there was a reason, but and I do like to say, Your Honor,
I don't want
he
extra stuff. I just need you to answer my question.
okay. That's fine. If he's willing to disclose his address, I'll disclose my address. That's fine.
Okay. All right. Then for both of you, I'm put non-disclosure, not requested. So y'all are both obligated to let the other party know where you live.
This part shows the judge taking complete control of the courtroom. Both parents are arguing over keeping their addresses private, but the judge makes it clear that dislike and distrust are not the same thing as family violence. He shuts down interruptions, demands straightforward answers, and forces both sides to finally agree that they must share their real addresses moving forward.
It might be in the court order that we do today. And then anytime that you move, you are to share that information in writing to the other parent. The only other issue I guess I got is exchange location. I think y'all mentioned two different exchange locations. We got to pick one. Uh, Ms. Akibu, what was it, a grocery store or something that you
No,
proposed?
sir. No, sir. No, Your Honor. I was asking that he meets me. It's a clubhouse here in my residence. Basically,
Oh,
it's my apartments.
I see. Okay, I got you.
And only because I do not have a car, Your Honor, right now. So there's no way for me to meet him outside of my residence.
Okay,
I've been putting a lot of money to my child's daycare and a ton of expenses alone. So as far as a car right now, I do not have a car at the moment. And so him wanting me to go out and meet him somewhere is not going to be possible at all, Your Honor, under no circumstances.
okay.
I'm fully remote working
I
from
gotta ask
home.
you another question.
I'm sorry, Your Honor. Did you say?
I haven't asked any question.
Okay, thank you. Sorry.
Okay. All right. Let me go ahead and make my ruling here in this case. Obviously, the DNA tests are positive, so we're establishing Mr. Obaka as the biological father of this child. You have testified. I make a finding that there's been no family violence in the last 2 years. Y'all are not requesting a non-disclosure, so we're gonna share each other's addresses. Child support is $217 per month. Medical support is $75 a month. We're doing government medical for insurance. We've agreed that there's some back child support that's owed in the amount of $2,492, payable at $63 a month until paid in full. Court cost is billed. We'll do the exchange location at the mother's clubhouse. Normally, it would say that he's supposed to meet you at your door of your residence, so that clubhouse is that much different, and that way you don't have to worry about other issues. Y'all are both supposed to not smoke do any illegal drugs or be under the influence of alcohol when you're with the child, either before or during your possession time. So make sure that, I mean, you are allowed to drink, but not be under the influence when you're raising this child. And that goes for both of you. That really goes without saying. I don't have to put that in the order. No parent should be under the influence when they have their child with their presence. Um, it's as far as the other issues, I mean, I get it. Y'all don't communicate very well. That's what I hear from today is that y'all don't communicate very well, and you'll have other issues regarding exes or other people that are not involved in this thing because y'all have maybe you're married to other people.
Because even something as simple as a visitation exchange location turns into another heated issue. The mother explains she has no car because she is carrying most of the financial burden for the child's care and daycare expenses alone. It becomes another example of how poor communication and ongoing resentment are making even basic parenting arrangements difficult for both sides.
People are with other people as well as each other, so it's causing some problems. I understand that that's kind of normal, but we got to make sure that those other people don't interfere in this relationship. Y'all have a relationship with each other because you share a child together, and you're going to share a child together forever, no matter what any other party or any other people that are involved in your life have to say about it. And so they don't have any superior right to do something different. It's just the two of you as adults and the one child. Uh, I don't find a need for there to be supervised visits. I mean, obviously, it will be difficult. I wish that y'all could communicate better than y'all do to make things work, but it doesn't sound like y'all do. What I hear from both of you is number one, mother, you're just dictating how you want visits to happen. Mr. Abaka doesn't agree to it. Then y'all get into a disagreement about it. And ultimately, there isn't any visitation going on. So it's kind of both your faults, is what I hear, that both of y'all are at fault for there not being any visitation. Some of it may say because a child is crying, but that's not enough of a reason to deny visitation either. Obviously, the child's going to need an adjustment period, especially with the disabilities. As I said, I wish it could work out smoother, but y'all are not making it smooth. You're making it more difficult on your child because y'all cannot reach agreements, because y'all get into these other petty arguments or get other people involved that shouldn't be involved. Until y'all change that, it's going to be difficult for both of you. You're creating your own issues. Do not let other people create those issues. Do not create more issues for yourselves. You're not together. That's number one. Number two, we got to move on and help raise this child together. If you want him to participate in doctor appointments and things like that, inform him in writing, by email or letter or text. Say something when it is that he can go. If he needs to have special training on how to take care of the child, give him that information about when it is you go. Don't bring some other party with you when you go to do those trainings or you go to the doctor appointments. It's very simple. You can't say that he doesn't go, but you don't let him know when they are. I mean, it's kind of doesn't make any sense. Obviously, we were kind of waiting for DNA test results as well, so that's part of it too. We have to understand that we're kind of opening the door here to the kind of day one today because we didn't know for sure who the father was until today. So let's move on from here in a positive way. For visitation, I'm doing first weekends and third weekends from Saturday from 1 to 6. So it'd be 5 hours visitation unsupervised. It means that Mr. Agbaka is going to meet you at the clubhouse at 1 o'clock on those Saturdays. This is the first Saturday of the month. So this Saturday, you're going to meet at the clubhouse. You'll have the child ready to go. And
this is the major turning point of the hearing where the judge finally delivers his findings and doesn't hold back. He officially establishes paternity, rejects supervised visitation, and openly criticizes both parents for creating unnecessary conflict. The judge makes it clear that their inability to communicate is hurting the child more than anyone else, and his lecture becomes one of the strongest moments in the entire case.
He will be there at 1 o'clock, have the child until 6 o'clock. He'll come back at 6 o'clock to the clubhouse to drop off the child, and then it'll be basically every other week after that.
Your Honor.
It'll be until the child. I didn't ask for your answer. I asked for you to listen.
Okay.
So that's the problem. You're not listening. You're not listening to each other. You're not listening to the judge.
He doesn't have a
car
car seat. He doesn't have a car.
That's not what I asked. So we're 1 to 6 until the child's 4 years old. And then after the child's 4 years old, then standard visitation, which means Mr. Obaka has a right to visit on the first, third, and fifth weekends of each month, from Friday at 6 until Sunday at 6 every other weekend. And then holidays are also going to be split up in that order for visitation. All right, that's the order of the court that y'all must follow. The order will hopefully be sent out to you here soon. But understand that for this weekend, it is 1 to 6, unsupervised. Don't bring somebody over there for the exchanges. So don't bring your spouse, your significant other over there for the exchange, and exchange a child, then move on. Obviously, the child will cry. That's not, as I said, that's not enough of a reason to deny visitation. Y'all want to come up with something different that works better for your child? Y'all need to have agreements, not get into disputes like you have been. It doesn't sound like anything you've tried before has worked, but you have to change, uh, and understand that you are at fault as well before you can move on to do something more positive. All right, that's the order of the court. You almost follow that even if you don't agree, and they will try to email you a copy. You're done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you, sir.
Your Honor, what was the conservatorship type? I may have missed it.
Because the hearing closes with the judge laying down strict visitation rules and one final reality check. When the mother tries interrupting again, the judge immediately shuts it down and points directly at the core issue. Neither parent is listening. The court orders unsupervised visits to begin immediately and warns both sides that co-parenting will only work if they stop dragging personal drama into the child's life. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.